Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Civil Procedure Overview, the Federal Litigation Map. Let's begin. Civil procedure is a sequence subject. On the bar exam, the question usually asks where the lawsuit may be filed, whether the court may hear it, what claims and parties may be joined, what must be pleaded or disclosed, and what effect the judgment has later. Do not treat these as isolated memorized rules. Build the case chronologically: jurisdiction, venue, pleadings, motions, joinder, discovery, trial, judgment, and preclusion. The MBE tests the federal rules of civil procedure and related federal statutes. California essays may test California procedure, but the MBE is federal. When a fact pattern says federal court, assume the federal rules unless the issue is eerie, claim preclusion, issue preclusion, or a state law element supplied by substantive law. Black letter rule. A federal court must have subject matter jurisdiction over the action. The two major bases are federal question and diversity. Subject matter jurisdiction can never be waived, can be raised by any party or by the court at any time, and if absent requires dismissal. Federal question. A case arises under federal law only when the plaintiff's own well-pleaded complaint establishes a federal claim. A federal defense, counterclaim, or anticipated constitutional issue does not create federal question jurisdiction.
Diversity.
Diversity requires complete diversity between all plaintiffs and all defendants, plus an amount in controversy exceeding $75,000, exclusive of interest and costs. Individuals are citizens of their domicile. Corporations are citizens of both their state of incorporation and the state of their principal place of business. Unincorporated associations take the citizenship of every member. Supplemental jurisdiction. Federal courts may hear additional claims that form part of the same case or controversy, meaning they arise from a common nucleus of operative fact. But in diversity-only cases, plaintiffs generally cannot use supplemental jurisdiction to evade complete diversity for claims against parties joined under certain joinder rules. Personal jurisdiction asks whether this defendant can be forced to litigate in this forum. The analysis has two parts: a statutory basis and constitutional due process. Most MBE questions focus on due process. The defendant must have minimum contacts with the forum such that exercising jurisdiction is consistent with fair play and substantial justice. General jurisdiction exists where a defendant is at home. For individuals, that usually means domicile. For corporations, it usually means incorporation and principal place of business. Specific jurisdiction exists when the claim arises out of or relates to the defendant's purposeful contacts with the forum. Venue asks which federal district is proper. Venue is generally proper where any defendant resides if all defendants reside in the same state, or where a substantial part of the events or property is located. Venue defects can be waived, unlike subject matter jurisdiction. The complaint must contain a short and plain statement showing entitlement to relief. Under modern plausibility pleading, conclusory allegations are not enough. The pleaded facts must make liability plausible. Rule 12 motions are early defensive weapons. Lack of subject matter jurisdiction is never waived. Personal jurisdiction, improper venue, insufficient process, and insufficient service of process are waived if omitted from the first Rule 12 response. Failure to state a claim and failure to join a required party may be raised later, but timing still matters. Answer. A defendant must admit, deny, or state lack of knowledge. Affirmative defenses must be pleaded, including statute of limitations, residential judicata, fraud, duress, and release. Joinder rules determine who and what may be included. Permissive claim joinder is broad. A plaintiff may join any claims against an opposing party. Claim preclusion makes this important because unasserted claims arising from the same transaction may later be barred. Party joinder, intervention, impleader, interpleader, class actions, and compulsory counterclaims each have their own triggers. Discovery is broad but proportional. Parties may obtain non-privileged matter relevant to any party's claim or defense and proportional to the needs of the case. Work product is protected, especially attorney mental impressions. Privilege is stronger than work product and usually cannot be overcome by need. The Seventh Amendment preserves a jury right in federal civil actions that are analogous to suits at common law. Legal claims are tried to a jury before equitable claims when factual issues overlap. Summary judgment is proper when there is no genuine dispute of material fact and the movement is entitled to judgment as a matter of law. Preclusion is the exam's final act. Claim preclusion bars relitigation of the same claim between the same parties after a valid final judgment on the merits. Issue preclusion bars relitigation of an actually litigated and necessarily decided issue, often even in a later case involving a different claim. California procedure differs in important ways. California uses complaints and demurrers, has its own rules for venue and service, and recognizes broader primary right theory for claim preclusion. California essays may ask for California-specific pleading or preclusion rules, but an MBE question expects federal doctrine. Do not confuse subject matter jurisdiction with personal jurisdiction. One concerns the court's power over the type of case, the other concerns power over the defendant. Do not let a federal defense create federal question jurisdiction. Use the plaintiff's well-pleaded complaint only. Remember that some Rule 12 defenses are waived if not raised at the first opportunity. Separate venue from personal jurisdiction. A district can be constitutionally proper, but still an improper venue. Always ask whether supplemental jurisdiction is limited by the diversity plaintiff restrictions. MBE civil procedure questions reward order. Identify the procedural stage, name the governing rule, and apply the precise consequence. If the question asks what a party may do, think joinder, amendment, discovery, or motions. If it asks what a court must do, think jurisdiction, waiver, mandatory dismissal, or preclusion. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.